Welcome back, everyone, to victimology. In particular, we are learning about victimization as it occurs within the criminal justice system. And any discussion of victimization from the criminal justice system would be incomplete without including a discussion about racial profiling. So, what exactly is racial profiling? Most of you have probably heard this term before. You've probably know people that have experienced it. But what we're talking about here is the discriminatory practice by law enforcement, where they target certain individuals based on the color of their skin, or more specifically, based on their race, ethnicity, religion, or national origin. To be sure, this is an unconstitutional practice, yet it does continue, or at least there are accusations that it continues. So, in other words, racial profiling occurs when law enforcement officers rely on specific identifiable features pertaining to somebody's racial or ethnic background and use that information to decide who they're going to investigate, who they're going to stop and search and question. Right? They use those racial markers as a guiding post for their law enforcement duties. So some of you may have heard this term or this phrase, driving while black. So in particular, in the wake of a lot of the civil unrest that happened after Michael Brown died and Eric Garner died at the hands of white law enforcement officers, right? There was a lot of attention brought to the experience of black Americans, in particular black men in America, in their interactions with police. So what we're talking about, when you hear the phrase driving while black, is they're really referring to this hypothesis or argument or idea that police officers excessively target minority drivers. They stop them more frequently than they do their white counterparts. Or they treat those drivers differently than they do white drivers during such a stop, specifically because of their race. Now, that might be completely and solely a result of their race, or it might be even just in part. So if their race is at all shapes how they are treated, then that constitutes racial profiling. Now, of note, white drivers in America are more likely to be stopped for speeding than are black drivers. However, this is one of those decisions to make a stop that is an objective standard, right? The officers point the radar gun in the cars. If you're over the speed limit, they stop you. It's very obvious. However, when we see African Americans experiencing higher levels of being stopped, it's normally over more subjective measures. So, for example, they're more likely to stop them to check their documentation, make sure their license is up to date, make sure that their car's registered, and those types of things. One study in particular found that police were almost twice as likely to stop black drivers without any reason, or at least not provide a reason, than they were white drivers. Now, there's also been some people in these racial minority communities that have experienced a similar phenomenon while they were a pedestrian, while they were on foot. And this is referred to as walking while black. So you'll hear these ideas of driving while black or walking while black. And what the basic idea is that they're just going about their life, but they're black. And being black is what makes them targeted. And whether or not it's actually happening may not be as important as the fact that it's perceived to be happening. Because imagine for a moment that you were walking to class as you always do, but you felt like people were watching you specifically because of your racial background. And that is how people feel. Many people in this country feel. And that is a result of the institutional discrimination that we talked about on Monday, right? That permeates throughout our society and resonates at an individual level. So some people argue that racial profiling is merely a behavioral consequence of police culture, right? Police are on high alert. They are suspicious of everyone. They are thinking about their own safety and the safety of civilians around them. And so it's their job to be suspicious, right? And the more they go about their job and the more interactions they have with certain types of people, this anticipation of or assumptions about people's behaviors or character is just a result of living in this high alert, highly suspicious culture that is law enforcement, right? So one of the interesting phenomenons that has been studied at length. So racial profiling has gotten, as you might imagine, considerable amount of scholarly attention, right? People are interested in why this is happening, what the consequences of this are, what the prevalence of it really is, if it's overstated or understated, and how this is affecting the police officers' abilities to do their job, whether or not it is helping or hurting. But one avenue of research has looked at how police officers make sense of these accusations of racial profiling. So this deflection rhetoric refers to the speech or thought processes that police officers use to kind of attend to or respond to or react to accusations of racial bias. In other words, this is how they justify accusations of racial profiling. So there's three elements of deflection rhetoric. So if you hear a police officer talking about it, the first is called the intolerance of intolerance. And this is, they'll deny that racial profiling exists in their agency by pointing to changes in their organizational structure. So they'll say, our agency, we don't tolerate it. So you can't say that we're intolerant because we are intolerant of intolerance, right? So they're kind of saying that we've been restructuring ourselves to demonstrate our commitment to diversity and tolerance and inclusion and fairness. The second is the idea, this conversation about multiculturalism. So you'll hear them say things like, well, we can't possibly be engaging in racial profiling because we've improved our recruiting mechanisms, we've improved our diversity among our officers, and they're way better than they were in the past. So certainly now there's not signs of racial profiling. And the final one is this discourse of blaming the victim. And by victim, I mean here target of profiling. So they will say something like, well, if there's a problem, it's somewhere else. It's in those individuals that are claiming racial profiling is existing. It's not on us. We're doing our job and keeping people safe. But does why they're doing it really matter? Does how they justify it really matter? There's been this push amongst academics to really focus on racism from the approach that the consequences of it are what matter and what need our attention, rather than from the view of the perpetrator's motives. Ooh, sorry about that typo, guys. That's embarrassing. Yikes. Anyways, right, so this idea of, I want you to think about, as we finish this module, think about racial profiling in terms of its consequences for society, for individuals, for police officers, for police community relations, for law and order, right, for the criminal justice system as a whole. What are the consequences of racial profiling? Okay. Now, it's important to note that although racial profiling systematically enacted policies of racial profiling are unconstitutional. However, there are certainly legal grounds that allow officers to make inferences about a person based on their race or national or ethnic origin. Okay, so there are two important Supreme Court cases, and y'all as criminal justice majors, I cannot emphasize to you enough how important these two cases are. It is crucial that you understand them because A, they are a key part of the criminal justice system, how it operates, but also they have a lot to do with our rights today and understanding our rights and protections that we do and do not have. So the first case is Terry v. Ohio, and this was a landmark case that established the right for police officers to stop and frisk suspicious persons. So you may know this as the Terry stop. Okay, what Terry v. Ohio established is often referred to as the stop and frisk rule, but more importantly is that it set the standard for conducting such a stop and frisk at reasonable standard or at reasonable suspicion. And we will continue this after a brief video that will give you a little background about the case.
I hope this finds you well. Ever heard the phrase stop and frisk or Terry stop? Well, the case today is where it comes from. A Terry stop allows law enforcement to stop an individual and frisk them for weapons without probable cause. Today's case is Terry versus Ohio, decided in 1968. Here are the facts. A detective in Cleveland was patrolling downtown when he noticed two men, Terry and Chilton. The two kept walking back and forth between one particular store and a corner where they would confer. A third man was also seen by Officer McFadden on one of the meeting occasions. McFadden, believing the men were casing the joint, approached them and asked for their IDs. The men began to be evasive. McFadden decided to spin Terry against the wall and pat him down. He felt what seemed to be a gun and ordered the men into the store. The pat down of Terry was on his outer garments only. In the store, McFadden took a revolver out of Terry's coat and found another gun in the coat of one of the other men. They were both charged with carrying a concealed weapon. The court had to decide whether police can stop and frisk an individual they suspect to be armed and dangerous without probable cause to arrest. The court ended up holding that under the Fourth Amendment of the United States Constitution, a police officer may stop a suspect on the street and frisk them without probable cause to arrest if the officer has a reasonable suspicion that the person has committed or is committing or is about to commit a crime and has a reasonable belief that that person may be armed and presently dangerous. The court had to balance the protection of the Fourth Amendment against the danger to the public or bystanders or cops themselves. Remember, the Fourth Amendment protects a person from unreasonable searches and seizures. Here, there is both a seizure, which is the stop, and a search, which is the frisk. The court called a stop and frisk minimally intrusive, and the officer is allowed to conduct the stop and frisk as long as that officer suspects objectively that the person is armed and dangerous. Justice Douglas disagreed with the court and dissented, arguing that nothing less than probable cause can justify forcible detention of a person. My personal opinion.
Okay, so that's a really nice, concise little video. I stopped it there because obviously his personal opinion is not relevant for us, but he covers the overall the narrative of Terry v. Ohio nicely. So I wanted to share that with y'all. Now, one thing I want to clarify: the Fourth Amendment protects us from unusual or excessive searches and seizures. Now, to be sure, search is exactly as it sounds. That is them looking through your person, your place, and whatnot, your car. But the seizure, people often mistake that to think of that in terms of the police taking your stuff. And while that does include the police, their ability to take your things, it also, and importantly for the context of this discussion, involves the seizing of your person. So this is their ability to detain you, is really what we're talking about when we talk about seizure. So a crucial distinction to make here is between probable cause and reasonable suspicion. So we're going to start with probable cause. Okay, so the law enforcement officers have a burden of proof that they have to abide by. Unless they have this burden of proof, in this case, probable cause, then they can't arrest you. Okay, they can't search or arrest you without probable cause or a probable cause exception. And they can't stop you, i.e. seize you, and keep you against your will, detain you, right, without reasonable suspicion. So probable cause is a lesser standard than beyond a reasonable doubt, but it's more than a suspicion, right? In order for an officer to prove that they have probable cause, he or she has to show that they have facts and circumstances within their control and that they have knowledge from trustworthy sources that is enough that would convince a reasonable person that offense has been or is being committed. So again, probable cause is this idea that they have facts and evidence and knowledge from a reliable source that would convince a reasonable person to believe that an offense has been or will be committed. In a later case, Illinois v. Gates, it's not relevant. I don't expect you to know that, but if you're curious, it's Illinois v. Gates from 1983. The court kind of more firmly defined probable cause as a fair probability that contraband or evidence of a crime will be found if a search is conducted. So if they have a fair probability that they will find something that you should not have if they conduct a search, then they have probable cause. Now, this is in contrast to reasonable suspicion. Reasonable suspicion is a lesser standard than probable cause. They don't need those facts and knowledge from a reliable source. Instead, they must be able to have facts and be able to take things together and make inferences to have a reasonable officer reasonably believe that a crime had occurred or is going to occur. So again, it's less than probable cause. They don't have to have this kind of tangible evidence that's based on reliable sources, but it's not just a hunch. They can't just be like, oh, well, that guy doesn't look right. However, many argue that is how it's evolved. Okay, so in a nutshell, an officer doesn't need probable cause to hold you briefly, as long as they have a reasonable suspicion that you did or will commit a crime. And that, in a nutshell, is Terry v. Ohio. Now, when you're going through this and when you're reviewing this again later, I urge you to look through the notes. I copied and pasted a considerable amount of really useful information to the notes section of the PowerPoint, so make sure you reference that to help you out, okay? Here are some images that should be pretty familiar to y'all. We see this pretty regularly, especially even on TV, but also in real life. And this is a Terry stop, okay? So they're allowed to pat you down outside of your clothing. They are allowed to get kind of not up in your nooks and crannies, but they will pat you down, and they can go to a place that may make some people uncomfortable. But the point is that they're trying to locate a firearm that could potentially cause them or other citizens harm. Now, it's worth noting, though, that this isn't the same circumstances have essentially or have been expanded to in the vehicle. Okay, so sorry, this slide's out of order, guys. That's why I got all just skipped up right now. So I'm just going to pause, and all right, let's start that over. I'm sorry, that slide's out of order. So Wren v. United States is the other case that you need to know that is crucial, A, to you as a criminal justice major, but B, to understanding police practices and their right to make searches of your person. So these are fundamental rights that you should know about, okay? But they're also relevant to racial profiling. So if you've ever heard of the term a pretext stop, then you know where this is going, okay? A pretext stop was granted constitutional as a result of this case. So basically what happened was Wren and I forget his first name, but Wren was the main defendant, and he had a friend in his car, and they were driving around, and they were sitting at a stop sign, and they sat there for what the officer reported to be a considerable amount of time. I think he said something like more than 20 seconds, which, in all fairness, is kind of a long time to be sitting at a stop sign. Like, what are you doing at that stop sign, right? So it is enough to kind of raise an eyebrow. However, it's important to note here that the officer said not only was Wren sitting at a stop sign for an excessively long period of time, but more importantly, they were in what was known as as considered a high drug area. Okay, they were outside of Washington, D.C. when this happened. They also were in a Pathfinder that had temporary license plates, which again, depending on a police officer's experience, may raise suspicion. So they were suspicious of this vehicle, but they didn't have any probable cause. They didn't have any legitimate reason to believe that the driver or passenger had or were committing a crime. However, the Wren, as he was driving, he took a right turn at a stop sign and did not use his signal. And he was driving at what was considered an unreasonable speed. Now, if you don't look into that carefully, it makes it sound as though he was speeding, but from what I understand, he was going extremely slow. Like he was just kind of scudding along to turn the corner. He likely did not see these officers at all. So the officer pulled him over for failure to use their turn signal, and they're driving at unreasonable speed. And as the officer approached the vehicle, he spotted crack cocaine in the driver's hands. So they appealed they were convicted of federal drug convictions, actually, and they appealed it on the grounds that they said that this pretext traffic stop violated their Fourth Amendment right, which protects us from unreasonable searches and seizures. Okay, and usually this requires a clearly articulable suspicion to stop them, right? So in order to seize that person, they have to be able to clearly articulate their belief that this person has or will commit a crime. But the officer didn't have that here, right? Instead, he was acting on his hunch that they were behaving criminally. And so what he did was he used this traffic violation, right, this turn, to then have his way in and to investigate. So they can pull a police officer can pull any motorist over for any traffic violation, specifically for purposes of conducting a drug search. Now, this also is used for weapon searches, but it's most likely to be used for drug searches, because what happens is the officer can get close to your car door and go, I think I smell marijuana. You may have never had marijuana anywhere near your car or person in your entire life. But if the officer can say they smelled it, then that gives them grounds to search your vehicle. They know they do not need a warrant, and it is not an unreasonable search. So in the decision, Justice Alexander wrote that it doesn't matter why the police are stopping them, as long as they have some sort of traffic violation as an excuse. And it's almost a slap in the face how he says it as an excuse, right? You would hope that they're concerned about the traffic violations as well, because we have a shockingly high rate of traffic fatalities. But really what they're saying here is that the Fourth Amendment isn't enough. Like, it's not enough. If you committed a traffic violation, then they have grounds to search your vehicle or to stop your vehicle and go from there. So again, this is Wren v. US, okay? So this is in a nutshell. As long as an officer had probable cause to believe a traffic violation occurred, a subsequent search does not violate the Fourth Amendment, regardless of the officer's intent. So the officer could have been like watching you, following you, waiting for you to do something wrong. That is why they're allowed to do that. Okay, this isn't relatively new, y'all. I mean, it's 24 years old, but prior to that, that was not common practice. Nowadays, we all just accept that at face value, but that has not always been the case. So Justice Scalia wrote the majority opinion, and he talks at this concern that there may be some sort of what he calls selective enforcement, right, based on race. But he then goes on to say, if that's the argument you want to make, you picked the wrong clause. This is not a Fourth Amendment case. The Fourth Amendment case is clear. Once you've committed that violation, it's not unreasonable. If you think that you're being targeted because of race, you should have brought it under the Equal Protection Clause. And because he didn't, they lost. And this stands still to this day. So this brings us back to notions of disproportionate minority contact. With that in mind, right, disproportionate minority contact has this debate of, is it differential involvement or differential selection? That is, do people of different races engage in crimes so dramatically different that it results in this disproportionate representation of racial minorities behind bars? Or does the criminal justice system, law enforcement, courts alike, target specific people for selection into participation in the criminal justice system, right? And in the context of racial profiling, the question is it discrimination or is it aggressive policing? So consider this question as you move on to the discussion board. This is what you're going to be addressing here is, how do Terry v. Ohio and Wren v. United States form the legal basis for racial profiling? We talked about what both cases do, but now I want you to apply what the consequences and decisions of those cases I want you to apply the consequences of those decisions to understanding how it forms a legal justification for racial profiling.